Today, we've got a gripping constitutional drama for you. It's the story of a brilliant idea to fix the justice system that, well, it almost broke it. And it forced the Supreme Court of India to take a hard look in the mirror and confront its own decisions. This is the incredible story of power, balance, and the landmark case of L. Chandrakumar.
So let's just get right to it. At the heart of this whole saga is one single explosive question. Can you just take away a high court's power? In the name of making things faster, can you just remove it from the judicial process? This one question set the stage for one of the most important constitutional corrections we've ever seen.
Okay, so where does all this begin? Well, like a lot of big stories, it starts with a genuine problem that everybody could see. India's courts were just drowning in cases, and that meant justice was getting delayed, sometimes for years. So the government came up with what seemed like a great idea: create a brand new, faster system of courts to clear the backlog.
And that solution? It was called the Administrative Tribunal. Think of these as special ops courts, right? They were created by the 42nd Amendment, and their mission was simple: handle very specific kinds of cases, like disputes involving government service matters, and deliver judgments way faster. On paper, it sounded like the perfect fix.
But, and you knew there was a but coming, didn't you? Here is where the trouble really started. In this race for speed, the new system was designed to take a massive shortcut. It was meant to completely bypass one of the most crucial players in the whole judicial game, the High Court. And what started as a practical fix was about to ignite a full-blown constitutional crisis. So let's put some dates on this real quick. In 1976, the Constitution gets the update to even allow for these tribunals. Then, in 1985, Parliament passes the act that officially brings them to life. And then comes the big one, 1987. A Supreme Court ruling in a case called SP Sampath Kumar gives this new system a very powerful and, as it turns out, very problematic stamp of approval.
Now, you really have to listen to the exact words the court used here. They didn't just say these tribunals were helpful. No, they called them an equally efficacious alternative to the high courts, even for something as critical as judicial review. You know, that superpower that high courts have to check if a decision is lawful and constitutional. The Supreme Court just said these new tribunals could do that too. That was a monumental statement.
And this table just lays it out so clearly. Look at the radical difference. Before, the path was clear. Case goes to the High Court, then you could appeal to the Supreme Court. But on the new path, the case starts at the tribunal, and then, boom, it jumps straight to the Supreme Court. The High Court, with all its supervisory power, was just gone, completely cut out of the loop.
So you see the clash, right? You had this really commendable goal, efficiency, smashing head-on into the fundamental structure of the Constitution. Sure, the new system was faster, but at what cost? A huge conflict was brewing, and it was over the very soul of judicial power in the country.
And this brings us right to the turning point. A legal challenge pops up that on the surface seemed pretty minor, but it was like pulling on a loose thread. And it ended up unraveling this giant constitutional puzzle that the Supreme Court itself had helped to create.
I mean, just listen to the court's own words from 1994. You can feel how serious this was. The judges said the new case had unmasked greater issues, and then they said it out loud. Their own previous judgment in Sampath Kumar needs to be reconsidered. That was a massive signal from the court that they knew something had gone seriously wrong.
You see, after that 1987 ruling, the situation got really confusing. The first view was clear: tribunals can substitute high courts. But then, in other cases, the court started saying things that completely contradicted that. They started ruling that actually tribunals are not equal to high courts, and they can't just ignore high court decisions. So, which is it? The whole legal doctrine was becoming a tangled mess.
Clearly, this confusion couldn't last. Something had to give. And so, the stage was set for the climax of our story, the landmark 1997 ruling in L. Chandrakumar. A special 7-judge bench of the Supreme Court was put together to sort this out, once and for all, and to finally rebalance the scales of justice.
And the verdict? Wow. It was decisive, and it was profound. The court laid it all out. They declared that the power of judicial review held by the high courts is a basic feature of the Constitution. That means it's an unshakable pillar that no law can ever take away. And if that's true, then it follows: tribunals can't substitute high courts, and any part of the law that tried to do that, unconstitutional. End of story.
This one quote from the judgment just sums up the new reality perfectly. Tribunals are here to play a supplemental role, not a substitutionary one. So, in plain English, they're here to help, to support, to be part of the team, not to take over the whole show.
So what does this all mean in practice? Well, here's the new corrected path. A case still starts at the tribunal, that's step one, but, and this is the absolute game changer, any appeal must now go to the High Court for review. The High Court is back in the game. Only after it's been through the High Court can a case move on to the Supreme Court. The proper judicial hierarchy was restored.
And you know, this was just a masterful act of self-correction by the Supreme Court. They saw a flaw in the system, a flaw they had a hand in creating, and they fixed it. They managed to keep the efficiency of the tribunals while restoring the absolutely vital role of the high courts as guardians of the law. The constitutional balance was preserved.
So, why are we digging up a case from 1997? Because its legacy is absolutely fundamental to how justice and democracy work in India today. It answers some of the most critical questions we have about the balance between getting things done fast and protecting our core constitutional principles. So let's boil it all down. What should you remember from this whole journey? 1. Judicial review is non-negotiable. It's an untouchable pillar of democracy. 2. High courts are essential guardians of the Constitution. 3. The search for efficiency can never come at the cost of our fundamental principles. And 4. Tribunals are here to support the high courts, not to replace them. That's the whole story.
And this all leaves us with one final, vital question that goes way beyond this one case. As we all constantly look for faster, more efficient ways of doing things in our world, this story is a powerful reminder to stop and ask, what are the fundamental safeguards that we can never, ever trade away? It's something worth thinking about.